to share a few housekeeping rules. Please keep your microphone on mute unless you're invited to speak. Kindly keep your camera off unless you're requested to or if you're presenting. Use the chat or Q&A feature to submit your questions and the moderator will address them during the Q&A session. This session will be recorded except for the Q&A session. The webinar will last approximately 1 hour and 30 minutes. We kindly request that you stay in for the entire session to gain the most value of it. If you find any or face any technical difficulties, please use the chat box to notify us. And lastly, presentation materials will be shared with all participants. Thank you, welcome all. I would like to invite Wakini to pick it up from there.
Sure. Thank you so much, Glory, and thanks everyone for honoring this invitation. My name is Wakini Njogu. I am the Strategic Communications Lead at Development Gateway. And so over the past couple of months, we've been working with Accountability Lab and Digital Public as Glory has mentioned, to explore strategic partnerships and mergers. And perhaps I can start by giving a bit of a background about how all this came about. And so, as you might all have observed, one of the big outcomes of the suspension and cancellation of the US government-funded projects has been the loss of resources for many organizations, and with that, a lot of uncertainty about the future. And so at the start of this shift, back in February, Accountability Lab began collecting data to try and understand the scale of the crisis. And the reality, based on the responses from over 700 organizations who responded, was quite telling. Nearly 25% of nonprofits and over 30% of for-profits said that they had just 30 days of finance reserves left. And those numbers for us really signaled an urgent need to build resilience across the sector before we lose critical work, before we lose institutional knowledge and partnerships and the like. And so in response, as I mentioned, Accountability Lab, Digital Public, and Development Gateway have been exploring strategic partnerships and mergers as a way to help organizations sustain their impact. What we've been doing is identifying and connecting organizations with aligned missions, sharing practical resources through a strategic partnerships and mergers toolkit, which we'll share in the chat, and also working to mobilize both technical and financial support through a proposed pooled fund and a network of experts. We've also been looking at how to help safeguard digital infrastructure, knowledge products, and intellectual assets so that organizations do not just survive, but also make sure that they can transition strategically. And with that, we are really excited to be hosting this webinar today alongside ISLP to dig deeper into what all this could look like in the Kenyan context. I will hand it to you, Sarah.
Thank you, Wakini. My name is Sarah Lulo. I serve as Executive Director of ISLP, the International Senior Lawyers Project. I echo the welcome extended by Glory and Wakini. We are delighted to partner with Accountability Lab, Development Gateway, Digital Public, and our Kenyan legal experts from Ashitiva Advocates and Waithira M & Co. Advocates, both based in Nairobi. A little bit of an introduction to ISLP for those of you who may not be familiar. We are an independent nonprofit charitable organization. We mobilize legal support on practical initiatives that advance the rule of law and support locally led global development in a manner that is more equitable, just, and accountable. We work in about 40 countries each year, about half of our work being in Africa. And we work with civil society organizations, governments, and social enterprises. And all of our work is demand-driven. Some of the work we do includes capacity building, corporate governance work, and transactional work, support with negotiations, whether it's contracts or other more complex transactions, including international and transnational ones. legislative review and law reform support, and more. And I will say that this partnership together, this webinar series, and this being the first of 3 webinars that we are developing on this topic, this one being for Kenya. Forthcoming webinars will address issues from the UK standpoint and US standpoint. This initiative together is an example of a strategic partnership. ISLP was mobilizing and finding ways where we can be of service in this moment to our fellow civil society organizations and NGOs that are navigating new complex issues relating to compliance, relating to different types of carving a path forward. And we felt that this type of capacity building and resource sharing could respond to the needs specifically expressed by nonprofits and dovetailed with work that was already underway by Accountability Lab and Development Gateway and Digital Public. So we're really happy to join forces and present this as a useful, we hope, tool and platform for all of you to learn and share your experiences as well, and hopefully help you identify and navigate new questions that are legal in context. And I will say that afterwards, if you do have legal questions or want to follow up with more in-depth questions relating to this webinar or other legal issues, please feel free to reach out to ISLP. We will put our contact in the chat as well, and we'd be happy to discuss those with you and be of service. With that, I want to introduce our first Kenyan legal expert who will be presenting, Candice Kola, who is a wonderful partner at Ashitiva Advocates based in Nairobi. Thank you, Candice. Over to you.
Thank you so much, Sarah, Glory, Wakini, and fellow partners and participants. Good afternoon and good day from Nairobi. Perhaps just a brief overview about Ashitiva, if we may, as well. We're a full-service law firm based in Nairobi, as Sarah has mentioned. We do offer corporate and commercial legal services and practice areas including business establishment, legal due diligence, corporate restructuring, and the like. And so we are very delighted to be part of this, joined by my colleagues, Charlene and Sharon, who are both part of the corporate and finance team. As mentioned, we are delighted to be part of this timely webinar, where we'll give an overview of mergers and acquisitions and winding up processes in Kenya. The discussion does come at a critical moment, particularly in light of recent global developments, most notably the shift in the foreign aid policy by the US administration, where we saw those executive stop orders issued, which have introduced considerable uncertainty for not-for-profits and other organizations that would rely heavily on aid, grants, and funding generally from the US and other Western countries. So in response, on our end, we've seen many organizations having to rapidly assess, as Wakini has said, their sustainability and to determine what would be the best course of action. For some, this has meant scaling down operations. For others, mergers with like-minded not-for-profits or enterprises also operating in Kenya, or even the wider East African and Sub-Saharan region. In more severe cases, an entire winding up of operations has also become a necessary consideration. So I think while the subject matter is broad and can indeed become quite technical, we have designed this session to just give some practical overview of key considerations for not-for-profits, which are right now navigating these decisions in the Kenyan context. We hope you'll find the session insightful and engaging. The part or portion we'll be covering, we structured this into 3 parts together with our colleagues from Waithira and advocates. The first part, which Charlene, Sharon, and I will review, would cover just an overview of the legal framework in Kenya, key steps which are involved in a merger, winding up procedures and general legal and operational considerations. The second part, which will be led by Waithira, we will consider just key tax considerations, and she will take us through what would be important for not-for-profits to bear in mind. And in the last part, the team will share just some practical insights, including what would be judicial trends we are seeing on this side of the globe, and examples from live matters, which we are also currently handling. I believe an important place to begin with is the legal framework, which is governing not-for-profits in Kenya, as well as just some principal statutes which regulate mergers and winding up in this jurisdiction. I think understanding that legal foundation would indeed help organizations navigate the processes, which with some level of clarity and also ensuring compliance right from the outset. We've also, as mentioned earlier by the introduction, prepared some brief material which would offer you some detail on these topics for your further reference. So not-for-profits in Kenya would take various forms. Some examples are companies limited by guarantee, which are governed by the Companies Act. We have private companies or subsidiaries, which would also fall under the Companies Act, together with foreign branch offices. Public benefit organizations are also another form of not-for-profits in this jurisdiction, which fall under the Public Benefits Organizations Act. Then lastly, another form which you'd come across would be trusts or trustees setups, which are under the Trustees Perpetual Succession Act. In terms of key statutes, which as we move through the presentation, we would note, we can mention a few of these as well. But at the outset, also to mention that Kenya is a common law jurisdiction, and much of our contractual and corporate legislation is rooted in English common law principles. This background itself also continues to influence the interpretation and the application of laws which are governing not-for-profits, mergers, and winding up processes in Kenya. So some of the statutes which you'd have to engage with on this side include the Companies Act, the Competition Act, the Consumer Protection Act, which is gaining some interest, particularly on fair rights for consumers and also in the market. The Income Tax Act, which is in the territory that Waithira will take us through. The Insolvency Act, AML laws, which primarily are led under the Proceeds of Crime and Anti-Money Laundering Act. We also have the Public Benefits Organization Act, as mentioned, and then the Transfer of Business Act. So turning to mergers, under the Kenyan Competition Act, a merger is defined as the acquisition of shares, business, or other assets, whether within or outside Kenya, that results in a change of control of a business, part of a business, or an asset of a business in Kenya in any manner. From that position, there are now several ways in which a change of control or merger can be achieved in Kenya. Some common examples would be by acquiring full control over the ownership or part of the ownership. Typically, this would amount to the acquisition of at least 50 plus 1% of the shares or the membership rights. Acquiring indirect control, for instance, securing board or member seat, which would allow the acquiring entity to materially influence the affairs of the target entity. There are options of joint ventures, whereby two or more entities would combine their operations or functions to achieve a common objective. And then lastly, for instance, asset acquisitions, whereby control is obtained through the purchase of key business assets rather than units of shares or membership. For mergers, the key work streams that we typically have, we can broadly categorize them into legal due diligence, corporate approvals, legal documentation, and regulatory approvals. I will briefly walk you through the first three work streams, being the due diligence process, the corporate approvals, and legal documentation, after which my colleagues Charlene and Sharon would then take us through regulatory considerations and other aspects that are material to this process. It's also perhaps worth noting at this point that these work streams do not always need to occur sequentially. With proper guidance from Council, they can often be managed concurrently, allowing for more efficient path to closing. For the due diligence, if we can touch on that now, and this is in addition to the commercial due diligence that parties themselves would typically undertake, the legal diligence review is a very critical step in any merger process. It would help to identify legal risks or impediments, to assess potential liabilities, and ultimately this informs the transaction structure and key terms in the contracts. In the Kenyan context, we would see the process typically involving a comprehensive review of several key areas of the entity or the not-for-profit, which would be its corporate structure and governance documents, the regulatory compliance status, any material litigation, any material contracts and obligations, assets which include real estate holdings, intellectual property, employment and employee matters, tax compliance, as well as environmental, social, and governance obligations where these are applicable. The key output from the diligence process is typically what we recommend as a red flag report, which is prepared by Council. The report would categorize identified legal risks into broadly deal breakers, which are your reds, your pre-closing issues, which are issues that or gaps that are identified during the process but have to be regularized before the transaction can proceed and be closed. And then we have your post-closing issues, which are your blues and your ambers that can be addressed after the completion of the deal. The diligence review is important because it typically and importantly would help parties then proceed with greater clarity and protect against avoidable legal and commercial surprises down the transaction path. Another key work stream in the merger process is obtaining the necessary corporate approvals from the governing bodies of the merging entities. The approvals may be required from members, shareholders, partners, or directors. This depends on the structure, of course, and the governance framework of each entity. Corporate approvals would importantly serve two main purposes in our view. Firstly, they provide that formal authorization for the transaction itself, confirming that the entity consents to proceed with the merger. And secondly, they designate specific officers or representatives who are then authorized to negotiate and sign the legal documentation on behalf of the entity. The failure to obtain proper internal approvals can indeed raise serious legal questions about the validity and enforceability of the transaction, particularly if there are any disputes which arise at a later stage. And for this reason, ensuring that all necessary approvals are in place and also properly documented is essential to protecting the integrity of the deal. For legal documentation, we would group these into perhaps three categories broadly as well. At the outset, you'd have your non-disclosure agreements. These are typically signed at the outset to safeguard the exchange of confidential information during the initial stages and mid stages of due diligence and negotiations. NDAs would help to ensure that any sensitive organizational and financial data is protected throughout the process. We then have your letters of intent and term sheets. Occasionally, this step is missed or overlooked, but we generally encourage parties at the outset to enter into a term sheet or a letter of intent, which would outline those key commercial and legal terms of the proposed deal. The document would provide a very helpful framework for then drafting the principal transaction documents. In Kenya, the term sheets are, of the most part, considered non-binding, except for maybe perhaps you see provisions on confidentiality, exclusivity, and governing law, which would be binding on the parties. Then the definitive transaction agreements which are now the legally binding documents that actually effect the transfer of the interest of the assets and also establish the rights and obligations of the parties. These would depend on the structure of the deal and would include, for instance, your investment or partnership agreements, your joint venture agreements, your share purchase agreements, shareholders agreements, the business and assets transfer agreements, share and stock transfer forms, depending on the form of the entity. In addition, where there are material suppliers concerned or third-party vendors and contracts that are involved, we also would require termination agreements, assignment agreements, and novations to ensure that those key supplier relationships are also properly transitioned and concluded, if necessary, as part of the transaction. I will now, at this point, hand over to Charlene. Charlene will take us through the key regulatory approvals, which are also involved in the merger process.
Thank you, Candice, for that detailed. Thank you, Candice, for that detailed introduction and background to mergers. So from here, I'll take you through the regulatory approvals, which essentially in Kenya are provided under the Competition Authority of Kenya. So for a merger in Kenya, there is a requirement for notification to the Competition Authority, and this comes as provided by the merger threshold guidelines, which give a set of thresholds to be met by the target and the acquiring companies. So we'll take a look at some of the thresholds under the Competition Act. So the first threshold that the Competition Authority requires is that the transaction should have a combined turnover of assets, whichever is higher in Kenya, to be a total of 1 billion. That's approximately 8 million USD, and a turnover of assets of the target undertaking, that's the target company, should be above 500 million. The second threshold is that the acquiring entity, which is in Kenya, should have a turnover of 10 billion Kenyan shillings, and the merging entities should be in the same market. And there's an exception to this rule, is that the rule only applies unless the transaction meets the common market for Eastern and Southern Africa competition merger thresholds, which I will discuss in the next slide. The next threshold is that the carbon, the entities, that is the target and acquiring entity, which are in the carbon-based sector, should have assets up to 10 billion. That's approximately 80 million. So for this type of undertakings, we should have a notification to the Competition Authority. Someone will then ask, what does the CAK look or determine whether a merger should go on. That means that what factors will they look at when I'm giving an approval? So the CAK examines the impact on competition in the market and also the market dominance, the public benefits, that's in regards to employment, will it create employment to the people of Kenya, and also the market access. So in terms of timelines, the Competition Authority has 30 days to request for additional information after you've lodged the notification. It must then make its decision within 60 days with a possible extension for complex cases. So the impact of the notification then will result into the CAK either approving, rejecting, or approving the merger with conditions. So a notified merger then cannot proceed without the CAK approval, and unauthorized mergers are legally void and can result in substantial penalties. I'll also take you through another set of regulatory approvals which fall under the COMESA Competition Commission and also other regulators in the sector. So for the COMESA Competition Commission, they also have a set of thresholds that will require target and acquiring entity to meet before they give that approval in Kenya. So if 2/3 or more of the turnover of the assets, whichever is higher, is generated in Kenya, then the CAK will require a notification. So some of the other regulators in the sector will also include the Central Bank of Kenya and also the Insurance Regulatory Authority, depending on the nature of the transaction. The next type of work stream that we're going to look at is the winding up process. So I'll take you through the procedure under the winding up mechanism. This is as outlined in the Public Benefit Organization Act. So this process may entail the registration of an organization, that's a public benefit organization, winding up or voluntary dissolution by an entity's governing body, or the Public Benefit Organization Regulatory Authority, that's the authority that governs this type of organizations. So in terms of the procedure, Section 61 of this Act gives the procedure, which is also dependent on whether the organization is a membership or a non-membership organization. So there are two kinds of procedures to be taken by these two types of membership. So for the membership organization, in terms of procedure, the organization should have resolution by a vote of at least 2/3 of its members of the organization, which is signed by their chairperson. And in the second type of organization, which is a non-membership organization, the authority will require a voluntary decision, which will be made by the governing body in accordance with the constitution of the organization. So in this type of voluntary decision, the organization has to state the intention of deregistering or winding up, and the reasons. They should also specify a date which should not exceed 2 months from the date of the resolution and on which the deregistration is to take effect. The company is also required to give a copy of the financial statements for the period of the financial year up to date of the resolution. In terms of the legal effects of now the winding up process. So once the authority receives the written resolution or the notice of voluntary deregistration, they will either cancel the organization certificate of registration and register it by amending the registrar maintained by the authority, or notify the organization in writing of the deregistration and confirm the date on which the amendment was made to the registrar. So the next question will be, how will the assets of the organization be dealt with at the point of winding up? So the Act provides that when an organization is deregistered or wound up, dissolves, its assets remaining after they've paid all up their liabilities shall be transferred to another public benefit organization having similar objectives. So this means that the assets, once the organization has paid up all the liabilities, the assets have to be transferred to another organization having similar objectives. So the next step will be also the organization seeking voluntary dissolution may designate one or more registered organization to receive its assets. So the organization can also choose which PBO or to take over the assets, but it should meet certain requirements. One, it's that it should be registered with the authority and should be in good standing at the time of the distribution of the assets. So the authority may also require official or members of the organization who can be found in Kenya to provide an inventory and the whereabouts of the assets of the organization. Also relating to the transfer of assets is another legal framework, which is the Transfer of Business Act, which now gives a guideline on how businesses can transfer their assets. So if any business is transferred, the buyer is liable for the liabilities incurred in the business by the seller unless they issue a 2 months notice to the public in accordance with the Transfer of Business Act. So they should give notice in the Kenyan Gazette and 2 national newspapers. After the expiry of, also it's important to note that after the expiry of 6 months from the date that the transfer of assets occurred, proceedings may not be brought against a buyer in respect of their liabilities. So there are some key post-winding up procedures that will be also undertaken after a public benefit organization has been wound up. So the organization within 1 month after the completion of the winding up and dissolution process or this relevant order of court, submit to the authority a written notice stating this fact, and also in the notice should confirm the status of winding up and give the relevant documentation. They should also provide a copy of the financial statements and statement of accounts for the period from the previous year to the date of the written notice. So winding up can also fall under the Companies Act. This is where the organization is registered as a company limited by guarantee. And there's 2 processes under the winding up process, which is voluntary winding up and also court-ordered winding up. So in terms of the voluntary winding up of a company under the Companies Act, it's commenced by solvent companies through members' resolution, which are also supported by the director's declaration of the solvency of the company, or by the way of a creditor's resolution following joint meetings of the members and creditors to appoint a liquidator. So it can also be through compulsory winding up, which is initiated by court proceedings to the Kenyan High Court, typically on grounds such as insolvency and failure to commence operations, or where it is just and equitable to do so. So in this case, the liquidator will assume full control of the company, and he will also oversee asset realization and debt settlement to ensure that the company ceases trading except where necessary for winding up. So the process concludes with the filings at the Register of Companies, where there is full compliance and statutory notices requirements, and also regulatory filings to ensure that the register is closed for such an organization. So in terms of the voluntary deregistration or winding up of a company, it's initiated through shareholders or directors of the company. This is under the Companies Act and or the Insolvency Act. So the procedure here is that a special resolution has to be passed and the company files the meeting minutes with the Kenyan Register of Companies and a statement confirming the company's solvency or the ability to clear their debts. The intent to dissolve is also published in the Kenyan Gazette, and if no objections are raised within 3 months, the company is formally struck off the register. So just a quick recap of the winding up process in terms of just a checklist, which will be able to share a more comprehensive document on the same. Resolution. So in terms of winding up, a resolution by vote of at least 2/3 of the members of the organization should be signed. That's for a membership organization. For a non-membership organization, a voluntary decision made by its governing body as per the PBO constitution. The company should also provide financial statements and statements of accounts for the period from its previous financial year up to the date of the resolution. Transfer of assets to a PBO organization with similar objectives. Provide to the authority an inventory and the whereabouts of the assets of the organization. Follow the procedure for termination of employment contracts. So at this point, I'll let my colleague Sharon take you through the procedure for termination of employment contracts.
Thank you so much, Candice. Thank you so much, Charlene. Very insightful. So when it comes to employees, our experience has taught us that once an entity makes the commercial decision to either merge or wind up, the manner in which employees are handled will either make or break that transaction. And Kenya is a particularly sensitive jurisdiction for 2 reasons. And the first is that the court cases in Kenyan courts drag for such a long time, sometimes even for decades. And you can see what the implications of that will be, particularly for an entity that has already made the decision to wind up and exit the Kenyan market. The other reason is that Kenyan courts are extremely favorable to employees. And depending on how you look at it, whether you're representing the employee or the employer, you realize that the burden of proof is very heavily on the employer. And for an entity that is trying to wind up, you do not want to be dragged in court to again try and prove that the process that you undertook was either fair or procedural. So the general rule is that no matter what the circumstances are, a reason must be provided for the termination of employment. We found that in the instances where there is a corporate restructuring, the reason that is most probably given is usually redundancy. And redundancy is described at Section 2 of the Kenyan Employment Act, but the detail of the procedure as well as the regulatory framework can be found at Section 40 of the Employment Act, which provides a very strict procedural framework which must be complied with by entities that are declaring redundancy. So the first of these requirements is that an entity must provide a clear and legitimate justification, which from the simple reading looks easy to do, except that down the road, when you're required to undertake consultation, we have found that entities are actually required to consult with their employees and discuss whether there are any other procedures or any other methods that can be undertaken to be able to circumvent the redundancy process. So you see that puts the various entities at a crossroad, because on the one hand, you've already made the commercial decision to let certain employees go, but on the other hand, you actually have to prove that you've done everything within your powers to avoid this redundancy process. The second tenet is that you have to provide the requisite notices. A cursory read of the Employment Act indicates that you need to just issue to the relevant labor office a 30-day clear notice, so that the date between when you issue that notice and the last working day of the various affected employees is 30 days. But our experience has been that the courts have added an extra 30 days into this statutory timeline, so that you're supposed to issue a notice of proposed redundancy, indicating that yes, you're considering redundancy, but that you're looking for other alternatives that will be acceptable in the circumstances. After 30 days of consultation with the employees, that's when you can come back and issue a proper redundancy notice that then runs until the last working day of the employees. So you see, there's a bit of confusion there, and that's the reason why we encourage all of our clients to take advice from counsel, because on the one hand, the Act says 30 days, but the courts are interpreting an additional 30 days to make it 60 days into the redundancy process. And then the final tenet is consultation, where the employer and the employees, including any union representative, have to be consulted. And the thing that we encourage all our clients to ensure is that make sure that there are actually recorded consultations. Just saying that you undertook the consultation is not enough. You actually have to give evidence either through video or written notices of the actual consultation process. The other tenets are the fairness, which means that you have to prove that the selection criteria was fair, objective, and non-discriminatory. And finally, you have to ensure that you pay the terminal dues to the employees. And employees are not the only stakeholders that are relevant to this process. You have to keep in communication all the other stakeholders, such as donors, beneficiaries, and even regulators, as has been discussed by my colleagues Charlene and Candice. So I'm going to hand over to Madam Waithira, who will take us through the tax touch points.
Thank you very much. Good evening, everyone. Thank you so much for joining. My name is Waithira Mugo. I am the farm leader of Waithira Co Advocates. We are a leading commercial and tax law firm that is based in Westlands. And what we do and specialize in is we help our clients navigate the complexities around tax, and we help them optimize their tax structurings, ensure that they are compliant on matters around taxes. A huge thank you to the organizers of the event. I think it's such an impactful, timely session. And what I would like to take you through, on top of what my colleagues Candice, Charlene, and Sharon have taken you through, is one of the very critical blind spots that, in my experience, I have seen organizations that are undertaking mergers or that are winding up, oversee, and not intentionally. It is easy to oversee it because it's not a critical function. And I think in the most well-thought structures and structures and systems when it comes to winding up, they are hidden costs that arise from that. Few minutes, I'll take you through some of the very key tax that we've seen when it comes to mergers or winding up or NGOs. Also take you through the key tax considerations that you should have in mind when you are either undertaking the option of winding up or to do to go through the merger route. I will also take you through some of the common pitfalls in my list. I will walk you through a tax what you should look out for when it comes to begin with. I think it's not a very nice whether you can hear me, Candice, or am I breaking? Can you hear me, somebody?
Waithira, I think you're breaking a bit. I can hear
It's
you
not
now.
working,
Thank you.
Okay, it's better.
Yeah, you were breaking for a moment, but now it seems stable.
Thank you, Wakini. So I'll just start again and say that tax is a very complex, I don't want to call it animal, but we all understand that it is not a very palatable topic to have. However, if you don't pay attention to it, it can have quite an expensive aftermath in a transaction, where you're looking at, winding up or merging. Now, some of the primary tax gaps that we've seen is most entities, when they choose the merger route, they assume that the tax exempt status of either entity is going to carry them through the merged entity, which is an incorrect position. I'll explain why. The other gap that we've seen is when the merging entities are doing an asset transfer, or a winding entity is doing a transfer of the assets, they may overlook critical statutory provisions. For example, the stamp duty application has to be lodged. It is not automatic. And they also may overlook that the assets that are being transferred have to be charitable to charitable entity transaction. Last but not least is that some entities or some clients don't pay attention to this marriage that you're having of two new entities. Are there any tax liabilities that either of the entity may or may not know that they have, that you could be inheriting by virtue of the merger? The next thing that I would like us to look at is what are some of the key tax considerations that we need to look out for. So let me start with, if you choose to do a winding up, right? Number one is that you want to ensure that the entity that you're winding up, all the tax filings of that entity are up to date. And when I say up to date, I mean up to the date of the formal closure of the entity. Why is this? Is because even though you close, you decide to wind up the entity, there's going to be a definite trigger from KRA, and that is the Kenya Revenue Authority, that automatically tells them that you're planning to close the business. And therefore, it's important to do a clean process where you make sure you're compliant. Number two is that you want to make sure that you deregister your KRA PIN. Why is this important? If you do not formally lodge a KRA deregistration, the Revenue Authority will assume that you're still in operation. And therefore, you will find yourself having closed the entity through the NGO board or the PPO regulatory authority. However, the penalties for non-filing are still accruing from a tax perspective. The other thing that you want to look out for is you want to make sure that you notify the authorities of your intention to wind up. So when I say authorities, like my colleagues have mentioned, you want to make sure that you've notified the PBO authority, you want to make sure that you've notified the NGO board, and last but not least, you want to make sure that you've notified KRA. If you're looking at merging, like I mentioned, it is important to realize that even though the two entities that are merging are tax exempt, that exemption does not automatically is not automatically carried over to the new entity. And therefore, it's very important to make sure that you make a fresh application to the Kenya Revenue Authority for a new tax exempt status. Number two, which is the very critical, is that you want to make sure that you conduct a full health tax check of the entities that are merging. Now, this is important because we've seen scenarios where two entities are merging. However, entity A has no idea that they probably have a prevailing debt with, or an outstanding debt with the Kenya Revenue Authority, and they get into a merging contract, without disclosing that. And that also means that you have pushed that liability into the incoming entity. Number two is that you also want to make sure that if you're closing or you're merging the entities, the new entity that you're creating has a clean tax record. I will walk you through what a tax health check should look like at the end of this presentation. The next thing that you want to make sure is that you move correctly in terms of the assets that you're transferring. Like I said before, the exemption of stamp duty when you're doing the transfer is not automatic. And therefore, you have to ensure that you make an application for this exemption to be allowed. At the end of this presentation, we are also going to give you a live case in Kenya, where an exemption was allowed and then later it was revoked by the courts. And therefore, it's very important to make sure that you follow the exemption procedure by the book. Last but not least, when it comes to merging, you want to address the staff transition. So if two entities are merging and you are probably conducting what Sharon has very well articulated. Is it a redundancy? What is that transition period looking like before redundancy? What are the tax payables that are payable from that process? If you're carrying over employees from one entity to the new entity, are you able to account for the transition period? Have you filed the returns for that transition period? A precautionary tale that we've always advised our client is that when you're undertaking a merger, you want to make sure that the agreements that Candice provided for are including clauses that protect both of the entities when it comes to taxes. So think of an indemnity clause or a clause that is able to separate who bears what liability if an assessment is done post the merger. The next thing that we want to consider is, next slide, please. The next thing that we want to consider is some of the common pitfalls that we've seen. So number one is we've seen entities get into mergers without doing the tax health check, and you find yourself having inherited tax debts that you're not aware of, right? So this is why it is important to do the tax health check. I think I need to mention that our revenue authority is very aggressive, and it is not confessed mostly in rooms, but a lot of people are receiving assessment notices in this period. And therefore, it is important to know that even though the assessment has not been issued during the merger, the government will still catch up with it. The other tax pitfall that we've seen is failure to notify KRA. And we've seen this where you do the formal process of winding up, for example, or you've done the formal process of merging, you've signed all the documents, you've sanitized the structure, but then the notification part of telling KRA now, look, close these two pins because we merged into a new entity. That is normally overlooked. And of course, that causes confusion. And it can also bring an expensive affair at the end because of the overlapping tax liabilities in all the entities. Overlooking stamp duty exemption, I think I will not belabor that, I've mentioned it. This is very important. Now, if two entities are merging, I'm being informed time is up. If two entities are merging, it is very possible to overlook what activities that either of the entities have been doing. So let's not assume that both of the entities are doing charitable objectives, and therefore it's very important to probe through the books and make sure that the entities are charitable oriented. Now, allow me 1 minute to just go through what a tax health check provides you with. And I think on a preliminary, I'll say this. A tax health check is like an X-ray that looks into the financial tax status of each of the organization. And therefore, you're able to tell, does this organization have a liability? Do they have any ongoing assessments with KRA? Or do they have any risks that we can anticipate upon the merger? So you want to look at when the entity was registered. Why is this important? Because then you're looking at, are you able to get the records that are needed within the statutory period, that is 5 years in Kenya? You want to look at the tax exemption status to make sure that the income that they have accrued in the last 5 years before the merger has been exempted, and the exemption certificate is valid. You want to look at what taxes that the entity has been registered for, because again, that will also inform how you word and how you structure your transactions. You also want to look at the filing compliance aspect of things. And last but not least, you want to ensure a proper transition so that you're able to say, we're not carrying this tax obligation, we're introducing this tax obligation. And you're also able to keep records that are able to support whatever structure that you've chosen. Thank you very much. Back to you, Sharon.
Thank you. Thank you so much, Waithira, for that insightful explanation. So we're going to go into the judicial trends and awards. And in preparing for this webinar, we undertook a desktop research particularly on the National Council of Law Reporting website. Unfortunately, we are not able to find any reported cases from our local courts on this topic that we are discussing today. So we're going to discuss examples, 4 examples. I'll discuss one, Charlene will discuss 2, and Madam Waithira will discuss the final one. And the one that I'm going to discuss relates to a client that Ashitiva Advocates was advising recently. And in this matter, our client found themselves in the unfortunate situation where one of their main donors suspended funding. And the aftermath of that suspension was that approximately 600 beneficiaries were left without the funding that they were expecting to receive from our client. So you can imagine the kind of backlash that our client was having to deal with. And some of the risks that we assisted our client to manage included possible claims for contractual liability for breach of contract. There was also possible claims for consequential losses. There was a very ripe litigation risk because not only had our client breached the contract with the proposed beneficiaries, but also these beneficiaries had entered into contracts with other third parties in anticipation of the original contract with our client. So the risk of litigation for unfair treatment and breach of contract was ripe. And finally, there was quite a bit of reputational risk and fallout because there are quite a number of stakeholders that had been involved in bringing together this program, including the national government through the Ministry of Education and the Ministry of Agriculture, and as well as a number of county governments, which had all pulled together. And it was through quite a bit of publicity as well. So our client was also facing that. So we are able to manage this through helping them to redraft some of their contracts, extending timelines in some of them, and properly terminating some of them when there was no other alternative, and obviously in drafting the communication that was used to all these parties, including the ones relating to public relations. So I'd like to invite Charlene to please speak about Nyumbani and Amref.
Thank you, Sharon, for that detailed explanation on the first comparative case. So I'll take you through 2 cases which are from non-profit organizations in Kenya. So the first one is African Medical and Research Foundation, that's Amref Health Africa. So Amref is one of the largest health-focused charitable organization, which has recently faced challenges in keeping up with the funding demands for its health programs in Kenya. So while it's still operational, it has had to reduce some of its projects by approximately 60% due to these financial challenges of funding and reduced international aid and shifting donor, which has now shifted the donor interests. The second case is Nyumbani Children's Home, also a non-profit organization which is a prominent orphanage in Nairobi, which provides healthcare for HIV positive children. And recently, as early as this year, 2025, after the US government froze US funding for 90 days, it led to the freeze and threatened the supply of antiretroviral drugs essential for the children's survival. So from these cases, we can see that although they didn't get to the point of winding up, they've faced challenges and having to reduce their large-scale programs in different operations. So at this point, I'll let my colleague to take you through one of the tax case. Waithira.
Thank you, Charlene. I will take you through this of Okia Omutata versus Cabinet Secretary, National Treasury, and 5 others. Now, this is a very interesting case because I think it's really shaped the way exemptions are issued in Kenya when it comes to taxes. Now, in 2019, an existing bank that we have called NCBA Bank formed a merger between NIC Bank and Commercial Bank of Africa, and they were granted an exemption on duty of about 384 million, which is equivalent to about $2.9 million. Now, what happened is someone challenged this exemption, and the challenge was based on number one, the exemption was issued without a clear justification of how it was rooted in matters of public interest. And then two is that it resulted to public revenue of the equivalent amount. And last but not least, the benefit was not really on the public as provided in the law, but the same was geared towards the parties who are merging. And when the court overturned this exemption, which meant that the parties indeed paid that stamp duty that was waived, I think it will allow to all parties that are looking into mergers or acquisition, either from a business perspective, an NGO space, is number one, you need to justify the exemption and it has to be in line with the prevailing provision. And number two, it is always important to have a cautionary budget because the political dynamics are always changing in Kenya and the law is also always changing. So just want to make sure that you're not caught off guard. And last but not least is just making sure that you keep proper documentation that support why the exemption was granted in the first place. Thank you so much. That is all for me. Back to Sharon.
I think it's really back to ISLP team. Thank you.
So thank you so much, Candice, Charlene, Sharon, and Waithira for those valuable insights into managing risk and compliance, especially for organizations considering, mergers and winding down. So now we'd love to hear from our participants. So if you have any questions,